You know, you've worked incredibly hard to build your business. You generate an income, you accumulate wealth.
And you spend a, frankly, ridiculous amount of time on things like growth strategies and marketing.
Exactly. And navigating tax planning too. But let me ask you a question. Have you unknowingly left everything you've built completely exposed to a single lawsuit? Or maybe a sudden audit from the South African Revenue Service, SARS, or even a future family divorce?
That's a heavy question.
It is,
Yeah.
yeah. But it's the exact reason we're doing this deep dive today. Welcome. Today we're exploring the incredible, and I mean often completely misunderstood, protective power of trusts in South Africa.
It really is a phenomenal topic. And to do this justice, we're pulling from some fantastic source material today. We're looking at a highly detailed newsletter called The Power and Protection of Testamentary Trusts. It gets dipped into the actual mechanics of how these legal structures function out in the real world.
Right.
And we're also integrating the expert advisory framework of Lumke Sturman. She's a specialized South African trust consultant. Our shared mission today is to cut through all that dense legal jargon. We want to focus on the empowering side of this. We're talking about building an asset protection fortress for your business today and securing your family's legacy for generations to come.
I really love that term, by the way, asset protection fortress.
It paints a great picture.
It does. Because when you look at the research provided in Lumke's framework, there is a genuinely shocking reality out there for most South African entrepreneurs. People are out there running highly successful trading companies, but they're holding all their valuable assets, their homes, their investments, in their own personal names.
Yeah, where they're signing personal sureties to get business loans.
Yes. They're completely tangling up their personal wealth with their business liability. So if the business hits a wall, their personal wealth it goes down with the ship.
And that is the fundamental flaw in how most people operate. It brings us straight to the core philosophy of Lumke Sturman's strategy. It revolves around one golden rule: separating ownership from risk. This is the anchor we really need to keep coming back to today. The strategy dictates that your trust owns the assets and your company carries the risk.
Right, so they're totally decoupled.
Exactly. By doing this, you're effectively creating a legal alter ego. The trust sits over here, holding the wealth safely, while the company sits over there, out in the wild, taking the daily knocks of the business world.
But wait, let me play devil's advocate for a second. If I'm an entrepreneur listening to this and I transfer my house and my investments into a trust, doesn't that mean I lose control of my own money? I think that's the biggest fear people have.
Oh, absolutely. That is a very common misconception. But there is a massive difference between ownership and control. You can be the founder of the trust. You can be a trustee, meaning you are the one making the investment decisions and deciding how the assets are managed. And you can also be a beneficiary.
So you're wearing all the hats.
You're wearing all the hats. You maintain control over the entire system, but you aren't exposing yourself personally. If a business deal goes sour and a creditor comes knocking, they can only come after what you personally own. Since the trust owns the house and the investments, those assets are completely walled off.
Okay, that makes a lot of sense. And what I found so empowering in the source material is that this isn't some secret loophole reserved only for the ultra-wealthy or, massive conglomerates.
What's fascinating here is that this specific structure is completely accessible and highly recommended for everyday small business owners, consultants, independent contractors, high-earning professionals. It shields your wealth from creditors, it simplifies your long-term tax planning, and it creates a continuity plan if something happens to you. Think of it this way. Your business protects your income, but your trust protects your wealth.
Okay, let's unpack this a bit further. Because protecting your assets while you're alive, what the legal world calls a living trust or an inter vivos trust, is really only half the battle. We also need to talk about what happens when you're no longer here.
That transition plan.
Right. And that brings us to the second major concept in our sources, testamentary trusts. From what I understand, these are trusts created entirely through your will, meaning they literally do not exist while you're walking around today.
That is the exact mechanism. With a living trust, you're transferring assets right now. You're dealing with the administration while you're alive. With a testamentary trust, your will basically acts as a dormant trust deed. It just sits in a drawer waiting.
Just waiting for the trigger.
Exactly. The moment you pass away, your executor looks at your will, transfers the specified assets to the trustees you've already named, and boom, the trust springs into existence. And the reason this is so critical is that it solves the massive, glaring danger of the default way most people handle their
The
estates,
direct bequest.
the direct bequest.
That's basically what we all assume is the normal thing to do, right?
Yeah.
You write a simple will, you say, I leave everything to my spouse, or I leave everything equally to my children. It seems incredibly clean.
It seems clean on paper. But for many families, leaving large sums of money or complex business assets directly to individuals creates catastrophic vulnerabilities. Unless your beneficiaries are highly mature, financially sophisticated, and have zero risk of divorce or debt, a direct bequest is often rolling the dice with your life's work.
Yeah, and there was this one case study in the newsletter that really stuck with me. It perfectly illustrates this danger. It was the story of the Singh family. So Mr. Singh was a successful business owner who passed away unexpectedly, and his will was incredibly simple. He left everything directly to his two children, who were only 8 and 11 years old at the time.
Such a tough situation.
Really tough.
Yeah.
Now, put yourself in Mr. Singh's shoes for a second. You do everything right. You leave it all to your kids, assuming your spouse will be there to manage it. But tragically, Mrs. Singh passed away in the exact same accident.
It's an absolute nightmare scenario. And here is where the legal mechanics kick in and why that direct bequest failed them so badly. Legally, in South Africa, minor children cannot receive a substantial inheritance directly. They simply do not have the legal capacity.
Because they're under 18.
Right. So because there was no testamentary trust written into Mr. Singh's will to catch those assets, the law dictates that all of that money must be liquidated and paid into the Guardian's Fund.
And from the newsletter's description, the Guardian's Fund sounds incredibly restrictive. It's administered by the Master of the High Court, right?
Yes, the Master of the High Court oversees it, and it acts as a very basic, ultra-conservative holding pen for minors' funds. It's not designed to aggressively grow wealth or manage complex business assets. It's just meant to keep the capital from disappearing.
Bare minimum protection.
Bare minimum. The investment flexibility is virtually zero, meaning the returns barely keep up with inflation. And if the family members raising those kids need money for school fees or medical bills, they can't just swipe a debit card. They have to go through lengthy bureaucratic court applications for every single withdrawal.
But the part that really made me wince was what happened when those kids turned 18. Because the Guardian's Fund operates on a strict legal age limit, the moment those kids hit 18, the fund handed over their inheritance as a massive, completely unrestricted lump sum.
Just dropped in their laps.
Exactly. They were essentially teenagers handed a fortune overnight with absolutely zero preparation or financial education. The newsletter noted that within 5 years, by the time they were 23, both of them had completely depleted their entire inheritance.
Which is heartbreaking, because it highlights how a sudden windfall can actually be destructive without structure. If Mr. Singh had set up a testamentary trust, the mechanics would have looked entirely different. He could have handpicked trustees, maybe a responsible aunt or uncle partnered with a professional independent trust company.
A team he actually trusted?
Yes. Those trustees would have taken ownership of the assets. They could have invested the money dynamically in the markets. They could have paid for universities seamlessly. But most importantly, they could have staged the distributions.
Staged distributions. How does that work in practice?
It means the trust deed could dictate that the kids don't get a lump sum at 18. Instead, the trust pays for their living expenses, but they only get, say, 10% of the capital at age 25 so they can learn to manage a bit of wealth. Then maybe another 30% at age 30, and the remainder at age 35 once their prefrontal cortexes are fully developed and they're established in life. A testamentary trust isn't just a bank account. It provides a structured financial education.
That separation of ownership and benefit really is like a legal superpower. And it doesn't just protect young kids from themselves. The sources detail how incredibly powerful trusts are at shielding wealth from other unpredictable life hazards, like divorce.
Oh, the divorce statistics are a reality we can't ignore.
No, we really can't. The newsletter highlighted the Governor family. Mr. Governor left his estate directly to his 3 children. One of his daughters had been married for 15 years, but eventually went through a really messy divorce. Because she received her inheritance directly into her own name, the divorce court found that the money had mingled with her marital assets. As a result, a massive portion of her inheritance was awarded to her ex-husband.
This raises an important question for you, the listener. Do you want the wealth you spent your life building to potentially end up funding the lifestyle of your child's ex-spouse? Probably not.
Definitely not.
The newsletter contrasts this with Mr. Governor's brother, who used a testamentary trust. When his son went through a divorce, the inheritance was entirely protected. Let's look at the mechanics of why. In a divorce, courts look at what the individual owns. But because the trust owned the assets, not the son, those assets were invisible to the divorce proceedings. The son could still receive income from the trust to live on, but the ex-wife had absolutely zero legal claim against the capital. The family wealth stayed permanently in the bloodline.
That is brilliant, and the exact same principle applies to creditors, too. There was a story about the Pillay family that perfectly illustrates this. The father left his hard-earned business estate to his adult children directly. What he didn't know, because families often hide these things, was that one of his sons had racked up massive secret business debts.
And we all know what happens next.
Yep. The very second that direct inheritance hit the son's personal bank account, his creditors swooped in and legally seized it to pay off his debts. The legacy the father intended to support his grandchildren simply vanished instantly.
It all comes back to that anchor, separating ownership from risk. If the father had used a testamentary trust, the creditors would have been powerless. They could only attach assets owned by the debtor. The trustees could have held the capital safely, and instead of giving the son a lump sum to be seized, they could have directly paid for his groceries, his rent, or his children's schooling, keeping the wealth completely insulated from his poor business choices.
Speaking of poor choices, I was fascinated by the Wessels family example. They utilized something called a spendthrift provision. How does a trust practically stop someone from blowing the money?
A spendthrift provision is essentially a strict set of instructions for the trustees. In the Wessels case, one of the beneficiaries was known for constantly chasing questionable, high-risk business ventures. He kept demanding large sums of money from the trust to fund these ideas. But because the trustees were legally bound by the spendthrift clause, they had the power to simply say no.
They just cut him off.
Not entirely. They continued to fund his legitimate needs, housing, healthcare, but they acted as an impenetrable wall, protecting the core capital from his bad ideas.
That's a huge relief for a parent, I'm sure. We've talked a lot about protecting wealth from bad actors, divorces, or poor decisions, but I want to highlight the deeply positive, caring aspect of this too. Because sometimes a beneficiary is just inherently vulnerable through no fault of their own.
The Chetty family.
Yes, the newsletter mentions the Chetty family, and this really got to me. They have an adult son with a severe intellectual disability. He will never be able to hold a job or manage money independently. A direct inheritance would have been catastrophic for him. He could have been easily manipulated or financially exploited by unscrupulous people.
Exactly. For the Chetty family, a trust wasn't about avoiding taxes or protecting a business. It was purely an act of profound love. They established a specialized testamentary trust tailored specifically for him. The mechanics of this mean that professional trustees are tasked with ensuring his housing is secure, his specialized medical care is funded, and his daily quality of life is maintained for the rest of his life. He is protected, he is cared for, and because he doesn't own the wealth directly, he can never be taken advantage of.
Here's where it gets really interesting, though. Alongside that incredible emotional security, we have to look at the financial mechanics, especially for you business owners who are rigorously tracking the bottom line. Let's talk about taxes, because my understanding is that trusts are usually taxed incredibly heavily in South Africa.
They are. Generally speaking, living trusts, the ones operating while you are alive, face quite aggressive punitive tax rates. SARS applies a flat 45% income tax rate to them and an effective 36% capital gains tax rate. It's designed to stop people from hiding their everyday income in trusts. However, testamentary trusts offer a massive, entirely legal structural advantage when it comes to minor children or disabled beneficiaries like the Chetty son.
Hold on, let me stop you there. How does that actually work in practice? How do they avoid that 45% flat rate?
It's a specific concession in the tax code. If a testamentary trust generates income, say from rental properties or dividends, and that income is utilized for the benefit of minor children or beneficiaries with disabilities, it's not hit with that harsh 45% flat rate. Instead, it's taxed at the beneficiary's individual tax rate. For a child with no other income, that rate starts at just 18%.
That is a staggering difference.
It really is. It means significantly more of the trust's income stays inside the structure to actually pay for your children's education and needs, rather than being handed over to SARS.
And from what I read, the tax magic doesn't stop with income tax. We need to talk about estate duty and generational savings. The newsletter shared the example of the Van Zyl family who are preparing to transfer about 20 million rand into a testamentary trust. How does a trust protect that from estate duty?
If we connect this to the bigger picture of long-term strategic thinking, the estate duty savings are astronomical. When Mr. Van Zyl passes away, his estate will pay estate duty on that 20 million rand to transfer it into the testamentary trust. That is unavoidable. But here's where the separation of ownership creates magic. Once those assets are sitting inside the trust, they do not belong to his children's personal estates.
So because the kids don't own it, their estates don't pay tax on it.
Precisely. Let's fast forward 40 years. The children have lived their lives, benefiting from the trust's income, and they eventually pass away. But that original 20 million rand plus all the compound growth, maybe it's worth 100 million by then, does not attract estate duty again.
Wow.
If Mr. Van Zyl had given the money to them directly, SARS would take another massive 20 to 25% bite out of that entire compounded amount when the children died. By utilizing the trust structure, the Van Zyl family is legally saving millions of rands in compounding taxes across multiple generations. The wealth just continues to grow uninterrupted.
The sources also mentioned something called a Section 7C tax. Now, the way the newsletter described it sounded terrifying for business owners with living trusts. How does this structure bypass that?
Let's use an analogy to explain Section 7C because it's notoriously complex. Imagine you have a living trust. You want to move your assets in, so you lend your trust 1 million rand to buy a property. Because there's your trust, you don't charge it any interest. Well, SARS looks at that and says, hang on, in the real commercial world, loans have interest. By not charging interest, you're essentially donating that waived interest amount to the trust. And then they hit you with a donations tax on that invisible imaginary interest every single year. That's Section 7C in a nutshell. It's a massive headache for living trusts.
But a testamentary trust avoids this entirely.
Yes. Because a testamentary trust is formed upon death, the assets flow in via an inheritance, not via a loan from the founder. So there is no loan, there is no waived interest, and therefore Section 7C generally does not apply. It makes testamentary trusts incredibly tax efficient and much simpler to administer.
That efficiency is amazing. And it seems that same structural efficiency extends to how you pass down a family business. Leaving business interests directly to multiple children sounds like a recipe for absolute disaster. You end up with fragmented ownership. Some kids want to sell the company, some just want massive dividends to fund their lifestyle, and the one child who is actually working there running the business is paralyzed and can't make strategic decisions.
The Ferreira family case study navigates this tension perfectly. The mother had built a 40 million rand manufacturing business. She had 3 children, but their lives were completely different. Only one child actually worked in the manufacturing business. The second child was a successful doctor, completely uninvolved. The third child, unfortunately, struggled with severe substance addiction.
If she left the shares equally to all 3 of them directly, the business would have collapsed under the infighting.
Exactly. Instead, she utilized a testamentary trust as a structural buffer. The mechanics work like this. The trust holds 100% of the business shares. The working child is appointed to manage the business subtrust, giving them full operational control without any interference from the siblings. The business stays completely intact and continues to grow. Meanwhile, the trust pays out a portion of the profits as dividends to support the doctor, and it specifically funnels funds to safely cover the rehabilitation and living needs of the third child, bypassing their addiction entirely. It saved the business and provided for the family based on their actual individual realities.
But hearing all of this, the tax nuances, the spendthrift clauses, the subtrusts, it sounds incredibly daunting. If someone listening wants to set this up, it clearly isn't a weekend DIY project.
It is highly complex, and the absolute biggest mistake you can make as a business owner is trying to draft this yourself, or worse, naming the wrong people to run it. The newsletter gave a stern warning using the Hendricks family disaster. The founder wanted to save money, so he just named his 2 best friends as trustees of his living trust. The problem: they were exactly the same age as he was. Within 10 years of the trust being created, both of those friends had died. The trust deed was so poorly drafted that it didn't specify how to appoint successors. The entire structure froze, and the family descended into a hugely expensive, multi-year legal mess in the high courts just to get access to their own money.
So what does this all mean? It means that if you are going to build an asset protection fortress, you need an expert architect. You need someone who understands the blueprints. And that is exactly where Limke Sturman's framework comes into play. She is a dedicated trust consultant and asset protection specialist in South Africa. Her entire mission isn't just to sell you a document. It is to educate and empower business owners to build these structures intelligently and compliantly.
What is particularly impressive about her approach is how it acts as a structural solution to the massive administrative burden of trusts. The corporate regulator in South Africa, The CIPC, along with SARS, they have incredibly strict compliance laws for trusts now. If you miss a beneficial ownership register update or fail to file the right resolutions, your trust can be deemed a sham and you lose all that protection. Lohmkuss offers very clear, transparent packages to remove that stress entirely.
Yeah, the transparency is refreshing. Instead of vague hourly billing, her framework outlines exactly what to expect. For instance, if you're a newer business owner and you aren't even sure if you need a trust yet, she offers the foundation audit for R25,970. She comes in, analyzes your personal versus business exposure risk, assesses if you're actually ready, and gives you a concrete recommendation report. For more established business owners who know they need this and require a detailed roadmap, there's the Asset Protection Blueprint session for R39,990. That maps out your custom structure, showing exactly how your assets will flow safely.
And crucially, she offers annual maintenance for R47,900 a year. As we mentioned, a trust is a living, breathing legal entity. It requires annual trustee resolutions, continuous CIPC and SARS compliance, updating beneficiary registers, and constant red flag detection to ensure it remains a valid legal structure. Having a trust consultant handle that ongoing maintenance is what ensures your fortress remains impenetrable.
It really is the ultimate peace of mind toolkit. If you are generating income, if you are an entrepreneur with a turnover of between 1 and 50 million rand, and you want to ensure your wealth isn't wiped out by a single business mistake or a family tragedy, you need to look into this. You can visit her website at www.lumcasterman.com to join her exclusive asset protection waitlist and start genuinely securing your legacy.
To synthesize everything we have explored today, trusts are so much more than dry legal paperwork or tax avoidance schemes. They are dynamic tools of asset protection while you are actively building your business. And they are profound acts of love and strategic foresight for when you are gone. By anchoring your strategy and separating your wealth from your risk, you ensure that the legacy you have sacrificed so much to build actually serves the people you care about most, without the dangers of the open market.
I want to leave you with one final provocative thought to chew on. We have talked extensively today about protecting your children, protecting your business, and shielding wealth from creditors. But what about your surviving spouse? The source material highlighted the Moodley family. Mr. Moodley used a testamentary trust specifically to ensure his wife received trust income and top-tier medical care for the rest of her life, while guaranteeing that the underlying capital would eventually go to his children. Now think about your own current setup. If you were to pass away tomorrow and you left everything directly to your spouse, what happens if they eventually remarry 10 years from now? Is your current direct bequest setup inadvertently leaving your life's work exposed to a future stranger instead of ensuring it reaches your own children? It is a tough, uncomfortable question, but answering it is the first step to true peace of mind. Thank you so much for joining us on this deep dive. Take the time to look at your own estate plan, protect your fortress, and we will see you next time.